Materiality these days in M&A deals is normally a heavily negotiated issue. There's often a push and pull between sellers and purchasers. Sellers often try to qualify their representations and warranties in the definitive agreements with materiality to avoid being found liable for immaterial breaches or for immaterial damages. Parties typically include an indemnity basket to try to address this. For example, a basket might sound something along like, the seller will not be liable for a breach of a rep or warranty unless the loss suffered by the purchaser as a result of that breach exceeds a certain minimum or a material amount. Purchasers often attempt to include a double materiality scrape in definitive agreements. The provision typically excludes or scrapes the materiality qualifiers in sellers' reps and warranties for purposes of determining whether a breach or a rep or warranty has occurred, and also the amount of the indemnifiable losses resulting from that breach, hence a double scrape. So in response, sellers typically resist these materiality scrapes, arguing that such provisions render the materiality qualifiers in the reps and warranties as pointless. Also, they often contend that it saddles them with an unreasonable burden of disclosing everything they can possibly imagine in the disclosure schedules to ensure that they're not in breach of a representation or warranty that would be more appropriately qualified by materiality. On the other hand, purchasers, from their perspective, including a materiality scrape is already addressed in the indemnity basket. If not, the purchaser would first have to overcome the materiality qualifier in the rep and warranty, and then prove that the losses sustained exceed the minimum amount set out in the indemnity basket. Also, having a materiality scrape often avoids post-closing disputes over the meaning of what is material if the seller is found to be in breach of a rep and warranty that's also qualified by materiality. Oftentimes, the parties will compromise, and there's a middle ground. Materiality qualifiers will continue to apply to determine whether the seller breached a rep or a warranty, but if the breach is found to have occurred, that materiality qualifier will be ignored for purposes of determining damages. So the result is, it's still subject to an indemnity basket and other indemnity limitations in the definitive agreement, but the purchaser will be entitled to recover the full amount of its damages resulting from a breach. So basically, oftentimes sellers will say, I have not breached any material contracts prior to the date of closing. And even if I have breached them, if the damage is less than $10,000, the basket, then I don't owe you anything. It's only if it goes over that basket, becomes more material.